end of today's training. So again, today is brought to you by our partners over at Ventura County, and we are so pleased to be joined by Colleen Smith, one of the business solutions specialists there, who's here to share more about the resources available to employers like yourself. Good morning, Colleen.
Good morning. Thank you so much, Anna. Hello, everyone. My name is Colleen Smith. I'm a business solutions specialist with the Workforce Development Board of Ventura County. I just wanted to share a couple of our resources that we have. The first of which is the complimentary human resources hotline. There it is. Thank you so much, Anna. This is a hotline that any employer in the Ventura County area can use. As I said, it's complimentary, no cost. You can call this number 888-763-3174 Monday through Friday, and you can get all of your human resources questions answered. Hiring and firing processes, paid sick leave, employment handbooks, harassment, things like that. You can call as many times as you would like, and we encourage all of our employers to take advantage of this wonderful service. It's especially great for those that may not have a robust or large human resources team. You can call, like I said, Monday through Friday, no cost, as many times as you like, and you will speak to a live human being. So it's a wonderful service that we have partnered with CEA to provide. The other thing I wanted to share is that we are hosting our third annual New Year, New Career Job Fair. It will take place at the Oxnard AJCC, which is located in the River Park area of Oxnard. We have about 17 employers registered, and we still are looking for a few more. I will place the flyer in the chat. If anyone is interested in attending, please feel free to reach out. We are trying to have employers that are actively hiring with open positions. So if that's you, if you need recruitment help and you would like to attend our event, like I said, I will put the flyer into the chat. So you can either register or reach out to me directly. I will also put our business solution services guide into the chat as well as my contact information. If anyone would like more information about the Workforce Development Board, business solutions specifically, please let me know, and I will be happy to either jump on a Teams call or a quick phone call and let you know about all the wonderful services that we can provide. So with that, I know we're going to have a great webinar today, and I will send it back to our wonderful partners at CEA. Thank you so much.
Awesome, Colleen. Thank you for everything that you and your team over at Ventura County do for employers in your area. So now I'd love to introduce our trainers today. We have Virginia Young, our HR Compliance Director, delivering the content today. We have Vicki Simpson, our Senior HR Business Partner, supporting us again in the Q&A. So you are in great hands. And Virginia, it's all yours.
Great. Thank you, Anna. And thank you all for joining us today. We look forward to going over the new updates for 2026 to keep our California employers apprised of their new obligations for the new year. And thank you, Colleen and the Workforce Development Board of Ventura County for sponsoring this webinar. We are CEA. We partner with the Workforce Development Board to do this webinar and for the employer hotline that Colleen was describing. On behalf of my fellow HR directors here at CEA, we look forward to speaking with you on that hotline. Please don't hesitate to give us a call with your questions. At CEA, we are an employers association and a human resources consulting company. Our goal is to give our members peace of mind navigating these complicated laws. And in addition to the phone support, we also provide a multitude of written materials such as handbooks, forms, and fact sheets to help employers understand these new laws, as well as training and consultation services. Here are just a few of our members. We work with everyone from small family businesses to large companies to government agencies. So we really value our members and look forward to helping them all. We are not a law firm, just to be clear. This presentation is educational in purposes only and should not be relied on as legal advice. If you do have an issue that is of legal significance to you or to your company, you should speak to your own attorney. And with that, let's kick it off for 2026 updates. Our agenda today in the time we have together is to cover these broad areas of legal updates for 2026. We're going to start with wage and hour. We're going to talk about some additional changes and additions to leave and benefit laws that you need to know about, as well as some updated laws and developments in the area of employee rights. We're going to talk about AI's role in employment decisions and things you need to know about for 2026 relating to that. And we will keep you apprised of developing case law and regulations. So let's jump into wage and hour, something that affects us all every single day in our role as employers. We're going to talk about increases to the minimum wage, which is pretty much happens every year, and we're going to go over the changes for this year. Additionally, 2026 brought some changes to California's Equal Pay Act and pay transparency laws that are important to know about this year. And we will close out the wage and hour section with discussion of qualified deductions for qualified tips and qualified overtime, the no tax on overtime headline that you probably heard about earlier in the year when the federal HR 1 or One Big Beautiful Bill Act was enacted. So minimum wages are welcome present every new year. This year, California's hourly minimum wage for non-exempt employees rose to $16.90 an hour. That is up 40 cents. It was $16.50 in 2025. It is now effective January 1, 2026, $16.90 an hour. That is the minimum hourly rate your non-exempt employees need to be paid for each hour of work. This hourly rate also affects your exempt employees, your managers, supervisors, professionals, administrators who are exempt and paid on a salaried basis. To be exempt, one of the main requirements is that these employees be paid on a salary basis at a minimum level, which rises with the non-exempt hourly rate. So in 2026, the increase to $16.90 an hour for non-exempt employees resulted in about a $1,600 increase in the minimum salary required for your exempt employees. That is now $70,304 a year, up from $68,640 last year. This number is a multiple of the minimum wage. So every year the minimum hourly wage grows up, the exempt salary is going to go up as well. Fast food chains and healthcare industry employers, these are two industries where California has adopted a special industry-specific minimum wage. So if you are a covered employer under the fast food minimum wage law or the healthcare minimum wage law, your minimum wage and your exempt salary are going to be higher than the non-exempt hourly wage, and your exempt salary is also going to be higher than the exempt salary mentioned above. The fast food chain minimum hourly wage is $20 an hour. That has not changed in 2026. I don't think it changed in 2025 either. It has been at the $20 an hour for some time. But you do need to keep apprised of it. The Fast Food Council is in charge of making adjustments to that minimum wage. So keep your ears and eyes open for potential changes during the year for that. Healthcare industry minimum wage ranges depending on what type of healthcare organization you are. So if you are covered under the healthcare minimum wage law, you want to make sure you're familiar with those categories and what the applicable minimum wage is. There are scheduled changes to the healthcare minimum wage going into effect on July 1st. And again, the amount of those changes will depend on what specific type of organization you are. So if all that was not enough to think about with respect to minimum wage, none of us can forget about local minimum wage ordinances. There are over 40 cities or counties in California that have minimum wage laws that require non-exempt employees be paid at an hourly rate higher than the state minimum wage. Some of these cities have other types of employment ordinances that are in addition to California's laws, such as certain paid sick leave requirements or scheduling laws. The key here is that all of these laws, these local minimum wage, city or county minimum wage, or other laws apply based on where the employee is physically performing work. This may or may not be your office. If an employee is working at home, they're a remote employee hired to work from home, and they're working in their house in San Francisco or San Diego or one of the many cities that has local minimum wage or other ordinances, that those local ordinances likely apply to that employee. So you need to be aware of the local rules where your employees are physically performing work. The same would be true if you have employees working at a client site that may be in a different city. So you can follow these local minimum wage increases at the bit.ly link here on the slide. We track them. There are a number of January 1 increases. We do see sometimes increases at other times of the year for local minimum wages, but usually it's either January 1 or July 1 of every year. So you can keep track of those. And I also recommend, if you have employees working in a different city, that you go ahead and check that local government website wherever your employees are working. That will tell you what kinds of local ordinances they have in place so that you don't have any unpleasant surprises. One question we often get is whether these higher local minimum wages affect that exempt salary that I went over at the beginning. And I'm happy to report that they do not affect the minimum exempt salary. These local minimum wages, local city or county minimum wages, will generally affect only your non-exempt employees. It's only the state minimum wage that should affect that exempt salary. Okay, another development in the wage and hour area for 2026 involves California's Equal Pay and Pay Transparency Act. Just as a brief refresher, the California's Equal Pay Law has been around for a very long time, and it prohibits employers from paying employees of another sex, race, or ethnicity less money for substantially similar work. That's the basics of that law. There are some exceptions to this prohibition on paying less, where the employer can justify the differential based on a legitimate reason, such as seniority or merit, or other bona fide, legitimate, non-discriminatory reason. But again, it would be the employer's burden to show the legitimate reason for the differential. So in 2026, SB 642 made a number of changes to that law to provide clarification about some existing issues, and also to make some changes. So there are three main changes that we want to go over here. Before 2026, the Equal Pay Act prohibited paying less for substantially similar work to members of the, quote, opposite sex or another race or ethnicity. The 2026 amendments got rid of the word opposite. So it no longer refers to the opposite sex. It just refers to another, an employee of another sex, race, or ethnicity. And this may seem like a small one-word change, but it is important in the sense that it solidifies that the Equal Pay Act's protections apply to non-binary genders. Okay, it's not just male, female. So that one word is an important change, that you should be aware of, and make sure, ensure that employers have the understanding of the scope of the protections of that law. Another change a clarifying change that the amendment made is to make clear that for purposes of equal pay, wages is not going to be limited to the base salary or hourly rate. It's going to include a lot more. It will include pretty much the whole compensation package, including access to overtime pay, bonuses and stock options, incentive type compensation. It will also extend to benefits such as vacation, holiday pay, life insurance, and things like reimbursement packages, such like hotel accommodations and travel allowances. So it really is this mandate for equal pay for substantially similar work really is going to extend to beyond just the hourly rate or salary. It's going to apply to your whole compensation package. So it's important to be aware of that. These changes clarify that that is the case. The final thing that the Equal Pay Act, SB 642, did was it addressed the statute of limitations and periods of time that employees can recover for violations. Under prior law, prior to January 1, 2026, the statute of limitations, which means the time that an employee has to file their claim in court if they experience a violation or believe they have experienced a violation of the Equal Pay Act. It used to be a 2-year statute of limitations that was extended to 3 years only if the employer's violation was considered willful. The amendments in January 1, 2026 eliminated the 2-year statute of limitations and there's just a 3-year statute of limitations for all claims, regardless of willfulness or lack of willfulness. So that is one change. Another important change is that the SB 642 addresses the amount of time an employee can recover for violations if they file a timely claim. Okay. And so as you can imagine, for equal pay, an employee, if there's an Equal Pay Act violation, an employee might be experiencing a violation every time they get their paycheck, right? So it tends to be an ongoing sort of violation. And this law makes clear that as long as they file their lawsuit timely within 3 years of their last violation, generally, they can go back a full 6 years to recover damages. So that's an important distinction. As long as they get their claim filed timely, that doesn't mean their recovery period is limited to 3 years. They can go back a full 6 years. So along that line, we recommend that you take a look at your record keeping, how long you're saving payroll records and decisions about compensation, and make sure that you are keeping them for a full 6 years, because that could be the potential recovery period in the event of a lawsuit. Pay transparency is another component. It's similar to the Equal Pay Act, similar goals. That was also had some changes under SB 642. The pay transparency laws require employers to provide pay scales to employees. All employers have to provide pay scales to current employees for the positions that they are in, as well as to applicants for the position that they are applying to. If you have 15 or more employees, you are required to include these pay scales on all of your job postings where you may be a California employee may be hired. So this law has been in place for a while, but effective January 1, 2026, we have a different definition of what a pay scale is. In the past, pay scales had been interpreted as, just the full range for everybody holding that position. And as you can imagine, that would include someone who was just hired to someone who's been in that position for 10 or 15 years. And these pay ranges were huge and really unhelpful, to give the employee any real information. So they tightened up this definition for 2026, and a pay scale is now the expected wage range the employer reasonably expects to pay upon hire. Okay, so it's really just the starting salary range, not the entire range of salaries for that position. So this is an important distinction. You'll want to make sure, especially if you are having to put these pay scales on all your job postings, that you are aware of this change. The other wage and hour change that made news in 2025 was the One Big Beautiful Bill Act and the no tax on tips, no tax on overtime benefits that it provides. So the OBBBA had many, many tax related and other changes. What employers really need to know about from a wage and hour perspective, I think, are how to deal with this qualified overtime and qualified tip deductions. the OBBBA, I'm going to call it HR1 from here on out because I always miss one of those B's whenever I try to use the acronym. So I'm just going to call it HR1. What HR1 does is it establishes above the line tax deductions for employees on their federal income tax returns for, quote, qualified overtime and qualified tips. And this applies tax years 2025 to 2028. Um, so for employers, you're going to need to know how to report, how to recognize what are qualified overtime and qualified tips so that you can get your reporting to employees right at the end of the year. So let's start with what is qualified overtime for purposes of this deduction. Qualified overtime means overtime that the overtime premium that the employee gets for working the overtime hour, if only for overtime required by the Fair Labor Standards Act. This means only weekly overtime. The Fair Labor Standards Act requires time and a half overtime for hours over 40 in a work week. And the deduction that is, or the qualified overtime that is relevant to this deduction is only that weekly overtime for hours over 40. This can be confusing in California because we have lots of other times when overtime is required. We have daily overtime for hours over 8. We have seventh day in a work week overtime, and we have double time in certain situations here in California. Only that weekly overtime required by Fair Labor Standards Act is qualified for purposes of this deduction. And what amount is that? Is that qualified overtime? Is it that is the 0.5? If an employee gets 1.5 times their regular rate for their 41st hour, the qualified overtime premium that they can deduct is that additional 0.5 that they're getting because it's the 41st or 42nd or 43rd hour. Okay, so it's limited. It's a little complicated because we have California's additional ways that overtime gets triggered. So employers are going to need to work with their payroll providers to be able to tag or code qualified overtime payments for employees. For qualified tips, this part of the HR1 allows employees to deduct qualified tips up to a certain amount. It's an above the line deduction. So like for overtime, it's above the line, which means it can help employers whether or not, or people who itemize or don't itemize, it doesn't really matter. So it's going to help everyone. All employees are going to be interested in it, that's for sure. So this applies to tips from that are received by employees in occupations that are on this list published by the IRS of occupations that customarily and regularly received tips on or before December 31st, 2024. So IRS has come up with this list. It is here at this bit.ly link on the slide. There are over 70 separate occupations of tipped workers that are listed, everything from bartenders to water taxi operators. So you'll want to be familiar with this list and determine whether your employees' occupations are on it. For tax year 2025, you'll probably need to come up with the IRS hasn't made a requirement that the employees report the amounts that employees have of qualified overtime and qualified tips on the W-2. That will be a requirement for the tax year 2026, and you should work with your tax professional to be aware of those requirements. But the goal now is to be able to recognize them for tax year 2025. You'll want to give your employees an idea of the amounts that they have, but it doesn't have to be officially reported on the IRS on the W-2 this year. So just to summarize some wage and hour to-dos to make sure you're ready for 2026, in addition to the HR1, working with your tax and payroll professionals to make sure that you are ready for your reporting requirements and able to recognize these qualified overtime and tips. Other things, just as a reminder, check those minimum wage rates, both state and local. We do recommend that you update your wage theft notices for your non-exempt employees, just as a belt and suspenders practice when you make changes every year. Remember to adjust your salaries for exempt employees if needed. And if you have exempt employees where you just can't pay that, or don't want to, pay that additional salary, the job isn't worth it. You might consider transitioning to non-exempt. That's something that's a possibility if the raise in exempt salaries is too much. And finally, audit your equal pay practices and update your pay scales in light of the recent amendments. CEA does have a wage and hour audit and PAGA prevention package that can be purchased on our store. It walks you through these as well as other important wage and hour issues that you want to look at in your business. So we do recommend self-auditing and making sure that you're in compliance. Okay. Leaves and benefits is the next main topic of our presentation today. There are two main developments in this area that we'll go over. The first relates to crime victim leave, protected time off that employees get for when they or a family member is a crime victim. And there are also some corresponding paid sick leave updates in connection with that. So we'll talk about that, and then we'll talk about a new law that restricts retention bonuses and other similar agreements for employers. So let's start first with the crime victims leave. And if you went to our 2025 legal update, you probably heard a lot about crime victims leave because those laws were overhauled significantly for 2025. And just so if you missed that, or if it's faded in your memory, we'll go over what those changes were really quickly. In 2025, we saw a much broader definition of a victim. It was previously limited to victims of domestic violence, sexual assault, and stalking. It is now the definition of a victim is a victim of a qualifying act of violence. Which is further defined as basically any crime causing bodily injury or death, involving a firearm or other dangerous weapon, or the use or threats of use of force to cause physical injury or death. So broad definition of victim, transfer to the Civil Rights Department for enforcement of these employee rights. They were previously enforced by the Labor Commissioner only. They were authority was transferred to the Civil Rights Department, and these are now processed by that agency as part of the Fair Employment and Housing Act. And with those changes, the California Civil Rights Department issued a new notice, employee notice of rights under these laws. And this notice has to be given to employees upon hire every year, annually, regardless of whether there's an update or not to the notice. And upon request or anytime the employee informs the employer that they or their family member is a crime victim. So employers with 25 or more employees in 2025 had further changes that affected them in that there were additional reasons listed that employees could take time off from work. It was expanded to include things like further legal proceedings, taking care of a family member who was a victim, providing childcare, things like that. So there were expanded reasons for leave for larger employers, broader definition of a victim, new notice requirement, all things we dealt with in 2025. In 2026, the court, I guess the legislature realized there were a few more areas that they needed to kind of clarify with respect to employee court and crime victim leave. And so there were two main changes that were made this year for 2026 under AB 406. The first was that there were two additional crime victim leave provisions in the Labor Code that had not been transferred to the Civil Rights Department jurisdiction in 2025. These were transferred in 2026, and these two types of leave which were previously under the labor code sections listed on the slide, are really for employees who were or victims or family members of victims of certain specified serious felonies. And the leave allows them to attend judicial proceedings where think like bail hearings, sentencing hearings, parole hearings, proceedings where a right of the victim may be at issue. So these were bundled up in AB 406 and also transferred to the Civil Rights Department. So as you may expect, we'll be getting a notice from the Civil Rights Department that needs to be distributed. Another area where AB 406 made a change is, or a clarification is regarding the use of paid sick leave. And so just curious, what do we think? Can employees, would you think they could use paid sick leave during covered crime victims leave, or not? You can put your answers in the chat if you know one way or the other. I'll give it a second or two. Okay, so my guess, so yes, employees can use vacation and paid sick leave for crime victim leave purposes. So this is an expansion of, paid sick leave uses to allow them to use paid sick leave for all of these crime victim purposes. The law, AB 406 also amended the law to clarify that this also includes jury duty and witness duty. These are both types of absences that are protected under the crime victim leave laws. Even though the employee may not necessarily be a crime victim, these laws do allow employees protected time off when they are called to court as a witness under a subpoena or court order, or when they are called to jury duty. And AB 406 clarified that paid sick leave can be used for these non-crime victim reasons that are also part of the crime victim leave laws, the way they're drafted. So it's important to know, because if you weren't aware of that or didn't think that jury duty or witness leave might have been an appropriate use of paid sick leave in the past, it definitely is now. And you should make sure that your paid sick leave, crime victim and jury and witness duty leave policies are updated accordingly. So that was the crime victim leave change. We should expect a new notice from the California Civil Rights Department, addressing these two changes. And that is not out yet. I checked yesterday and it wasn't up, but we expect it to go up any day now. And we will send an alert out to our members, but you should look for it and make sure you distribute it once it is out. Okay, the other leave and benefits change I mentioned was relating to retention bonus type arrangements with employees. AB 692 applies to what we call stay or pay contracts. These are agreements where an employer gives an employee a sum of money, either maybe a new hiring bonus, or a retention bonus, or a tuition assistance payment. They give this money up front, but there is the agreement that the employee will have to pay it back if their employment ends before a certain period of time. An example would be a hiring bonus of $5,000, but if the employee is not there for a year for any reason, they have to pay it back, right? Those types of arrangements were pretty common. But in January, effective January 1, employers are generally prohibited from requiring this payback if the work relationship ends. So that might be a change if your business has programs like this where you have these upfront payments that require repayment later if employment ends. If you do, we would recommend that you consult counsel because there are a number of exceptions, but they do require carefully drafted contracts and agreements. So it's not something that you would, it's not something that automatically applies. You would really need some help getting those into place. So if you do have those if you do have those types of contracts, seek counsel as needed, so that your contracts going forward are compliant. And just going back, as I mentioned before, make sure with respect to the crime victim leave sections that you look back at your paid sick leave, crime victim, and jury and witness duty leave policies. And don't forget that CRD crime victim notice, of course. So, employee rights and protections, there are a few new laws, new regulations that you need to be aware of for 2026. The first, there's immigration-related protections. The CRD has implemented some automated decision-making or AI regulations you should be aware of. And there are some new personnel record requirements, as well as some notice and posting updates for 2026. So let's start with the immigration-related protections. This is SB 294, called the Workplace Know Your Rights Act. And this law really does two things. The first thing it does is it requires all employers to provide their employees the opportunity to name an emergency contact who the employer will contact in the event the employee is arrested or detained. The deadline for employers to allow employees to make this designation is March 30th, 2026. It's going to be an ongoing requirement for new hires, of course. So what it does, the purpose of this law is to, allow employees to have, know that someone will be contacted in the event that they are arrested or detained at work, so they can make legal arrangements if needed. They can make sure the kids get picked up from school. Their loved one or family member hasn't just, disappeared and not come home and they don't know why. So that's the purpose behind the rule. Its requirements are, for the employer, is to notify the designated contact if the employee is arrested or detained at the work site. And this is for any reason. The law went into place, I think, in response to arrests and detentions following during ICE immigration raids, but it really would apply to any arrest or detention. If the arrest or detention occurs off-site, but during work hours or when the employee is performing their job duties, the employer still has a duty to notify if they have knowledge of the arrest or detention. And there are some fairly stiff penalties that can be up to $10,000 per employee for violation of this law. So it's important to, get that, give employees the opportunity to make these designations in a timely manner and to have a system for following up and making the required notifications should an employee be detained. The second thing that this law did was it established a new notice requirement. The Labor Commissioner has a new workplace Know Your Rights notice that provides detailed information about immigration-related rights that employees have with respect to unfair immigration practices and rights, what happens if they're questioned by ICE, things like that. And it also includes detailed workers' compensation information. So, and whistleblower information as well. It's a fairly long notice. It's called the Workplace Know Your Rights Notice. It needs to be distributed by February 1, 2026, and annually thereafter, as well as to new hires. So this is something that goes in your new hire form, and employees get it every year, whether or not the notice changes. So it is the 13th of January. So you're have plenty of time to get your workplace Know Your Rights notices out to your employees. Those are available on the Labor Commissioner website. Moving on from the immigration-related protections to the AI. So there's been a lot of talk about AI regulation, use of AI in the workplace. There have been some cases this year where employers' hiring systems or resume screening systems have been challenged because the use of AI results in discrimination based on protected classes for employees or applicants, I should say. So the California CRD has issued some automated decision system regulations that address the interaction of California's discrimination laws and the use of automated systems in making employment decisions, such as whether to grant an interview, whether to hire, whether to promote, compensation, termination, layoff. So let's start with they don't use the word artificial intelligence necessarily exclusively in the regulations. Rather, the regulations cover automated decision-making systems. And those are defined specifically as a computational process that makes an employment decision or facilitates human decision-making through the use of artificial intelligence, machine learning, statistics, or other data processing techniques. So AI falls under this larger umbrella of automated systems that are either making a decision or facilitating a human decision about employment. And so it would include things like computer-based assessments or tests, predictive assessments about applicants or employees, automated systems that are measuring their skill or their reaction time or other abilities. Certainly it would encompass automated systems measuring like personality traits, or really in any way screening or categorizing your employees or applicants. It can also apply to automated systems that direct job advertisements or recruiting materials to targeted groups of people. Or things like screening of resumes, as in that case that I mentioned a minute ago. So what does it not include? It does not include, basic word processing or spreadsheets or things like that. It's where, you have an automated system using an algorithm that is going to sort or categorize or rank employees and applicants that are going to facilitate or make your employment decision for you. That's what automated decision making is under these regulations. And what the CRD reminds us in their regulations is that the Fair Employment Act's prohibitions against discrimination apply to the use of automated decision-making systems. Sometimes when automated decision-making systems or tools are used to make personnel decisions, they can result in what is called adverse impact discrimination. And this is not necessarily intentional discrimination, but rather it's a neutral process or a process that appears neutral that results in disproportionately large adverse outcomes based on protected class. That's what adverse impact discrimination is, and it is a basis for a discrimination claim under the Fair Employment and Housing Act. FEHA's, these new regulations reinforce that the theory of adverse impact discrimination can apply to the use of these automated systems. Additionally, the regulations impose a record retention for automated decision-making systems records of 4 years from the date the record is created or the personnel action that is involved, whichever is later. So you want to make sure you are aware of what kinds of systems you are using in your employment-related decisions, including if you are getting them from third parties or using them through third parties for screening, and you want to make sure that you are keeping the required records of those. The other thing to consider is that the regulations, the CRD's regulations expressly say that if you, as an employer, proactively perform anti-bias testing to make sure that the ADS systems you're using are not resulting in adverse impact, that can help you assert your defense that your decisions are legitimate and non-discriminatory. So there's a lot to consider there. The takeaway is, I think, is that there are these regulations out there that ADS will be looked at increasingly as it relates to adverse impact discrimination. And one final note, you may have heard in the news that at the federal level, there was President Trump issued an executive order basically instructing the EEOC not to pursue adverse impact discrimination type claims and requesting that certain statutes be amended to to change the statute and overturn court decisions relating to adverse impact discrimination. Um, but I think what's important to know is that adverse impact discrimination is by statute a viable discrimination theory in California and under federal law. And employers can still be sued in court for adverse impact discrimination. So even though the federal agency may not be pursuing these claims, it is still something that employers need to be aware of. Um, Let's see. There are new laws relating to personnel records and what employers have to keep in them. And oops, okay, sorry about that. Just a quick reminder, California requires employers to provide their employees with their personnel records, to inspect their personnel records and to receive a copy within 30 days of a request. They don't give us a great definition of what has to be in a personnel record. It does need to include records relating to the employee's performance and any grievance concerning the employee. In 2026, we have been given some additional information about what has to be in the personnel record, and that includes education and training records. If an employer keeps education and training records of an employee, those records need to be part of the personnel file, and they need to include all of the information in these bullet points on the slide: the name of the employee, the name of the training provider, duration and date of the training, the competencies of the training and skills that were included in it, and the resulting certification or qualification. So if you are keeping education and training records, you need to make sure that that your records are meeting these requirements, contain this information, and that they are becoming part of the personnel file. I believe this law was inspired by a number of mass layoffs where a lot of the employees had difficulty finding new employment because all of their certifications and educational certificates were not in their personnel files and not readily available to make it easier for them to find new work. So I think that's the impetus for the law, but it does apply to everyone. So if you are keeping those education and training records, make sure you are aware of these requirements. Let's see. Finally, there are some updated posters and notices. Some of them we have touched on in the course of our presentation today. As far as postings, things that need to be on your poster in the physical workplace, there is an updated Cal OSHA poster that was released in July. That's the Safety and Health Protection on the Job poster. The California minimum wage order and related posting changed effective January 1, 2026. So that is another updated poster for your bulletin board or your break room or wherever you post. And the Division of Labor Standards Enforcement updated their sick leave notice, the Healthy Workplaces Notice, for 2026 to largely to include the reminder that employees can use their paid sick leave for crime victim related leave and jury and witness duty. At the federal level, the EEOC has marked its discrimination poster, the Know Your Rights poster, as undergoing revision. It's been marked that way for several months now, but it has not yet been updated. But we do keep it on here so that you're aware that there is a potential update to that poster. So we'll keep you posted. No pun intended. And there are some updated notices. These are the brochures that we need to hand out to employees in addition to the poster, separate from the poster that's up on our wall. And we mentioned both of these in the course of the presentation. The Civil Rights Department will be publishing a new crime victim leave notice that needs to be given. And just as a reminder, it needs to be given to new hires annually, and then when you also have noticed that the employee is or their family member is a crime victim. And then the Labor Commissioner Workplace Notice of Rights is another notice that needs to be given out and has similar annual notice requirements similar to the crime victim notice. We do have updated 2026 labor law posters. If you like to get your posters all in one place, you can certainly order them. There's a link on the slide for that. So a summary of our employee rights sections. You want to make sure that you comply with that emergency contact, the new requirement for employees to identify a contact to be notified in the event of arrest or detention. We recommend doing this on a written form so that it's clear what it's for, it's in their file. We do have forms for that can help you comply, but we do recommend a written emergency contact form. Probably need to update your existing emergency contact form so that it specifically addresses the arrest or detention issue. We do recommend that you ensure a review of what AI or ADS processes you're using in your employment cycle, and make sure that your record retention requirements are compliant with that 4 years set by the new CRD regulations. If you are keeping those if you do keep training records, make sure that they meet the requirements of the new law, both in content and in actually being in the personnel file as opposed to some other file. And again, watch for those updated notices and posters. I think we are done. We are finishing a few minutes early, so I do have some time. I know Vicki has been working away on the chat and the Q&A. Are there any additional questions that have come up that if I'll stay on for a few minutes and until our 11 o'clock hour and answer them. So please feel free to put your questions in the chat. While we're waiting for that, I will say thank you again to the Workforce Development Board of Ventura County for sponsoring this webinar. And as a reminder, we partner with the Workforce Development Board to sponsor the hotline that Colleen told you about. We look forward to speaking with you then. If you are interested in membership, this slide gives you an idea of our different membership tiers and the benefits associated with them. We have memberships starting as low as $135 monthly. And as a general New Year employee checklist, we recommend that all employers purchase a labor law poster, update their employee handbook to reflect new laws, and make sure that their harassment prevention training is up to date. That harassment prevention training has to be done every 2 years. So CEA can help you with all of these things. And if you need assistance, and the QR codes on this slide and the bit.ly links will take you to our pages describing how we can help you with those. Your feedback matters to us, as Anna mentioned. We want to help improve our trainings and build our resources to help you through this process. So please take a moment to scan that QR code and leave us some feedback. And I'll leave that up for a minute. Are there any questions that you wanted me to address live, Vicki, or?
Yeah. Yeah,
Okay.
I have some of them I've addressed and I'm still addressing, but one is somebody states that they have a PR form number 941 and they want to know if they need to separate out OT on that. And I think that's a federal form.
Yeah, I'm not sure. I'm not exactly sure what that form number is.
It's a quarterly, I believe it's a quarterly form that they have to send to the IRS. So
okay.
my thought is that who asked us the question is that you probably need to contact them and ask them. We wouldn't necessarily know that. You should probably contact the IRS to see if you
Yeah, or your tax professional.
Yes.
Would know about how to fill out that form. I will say that beginning the tax year 2026, you're going to have to put the qualifying OT as part of the W-2 form. That I do know, but we do recommend that you work with your tax professional for that one. So.
And then there was another question on the pay scales.
Okay.
Do you only have to provide it for newly hired employees? Or if existing employees ask for it, do you have to give it to them too?
Yeah, that's a good question. So all employers have to provide existing employees the pay scale if they ask for it for their current position, or if they're applying for a different position, you have to provide the pay scale to any applicant or employee who asks for it.
And I would like to add that the pay scales apply to the position, not the person.
Good, very good point. Thank you for mentioning that, Vicki.
Yeah. And then I am looking up the link for the new Know Your Rights thing so I can post it in here for everybody.
Okay.
Right.
Thank you.
You're welcome.
Well, thank you for spending this hour with us, and we'll hopefully you've had a chance to scan that QR code and provide us some feedback. If you are taking this training for HRCI or SHRM credit, here are your training codes. The HRCI code is 728536, and the SHRM code is 26-4G W6D as in dog. So I'll leave those up in case you need to write those down. And I don't know, were we able to get that link to the Know Your Rights out in the chat? Okay, all right. So that's out in the chat if you need that. It's on the Labor Commissioner's website. So thank you, everyone. Thank you, Colleen. And thanks, Anna and Vicki.
Thank you, everybody.
Thank you all. So I do want to just remind you, Virginia, if you could put it back onto the survey slide, that would be much appreciated. So as I mentioned, and Virginia just spoke to it also, but this is how we continue to improve today's trainings is by hearing your direct feedback and making sure that we are serving you to the best of our ability, bringing you the most peace of mind possible. So if you can all take a moment. I set it up so you can either scan that QR code, or I dropped a link into the chat a moment ago. We'd appreciate your feedback so that we can help you. And other than that, I want to say thank you again to Virginia for sharing your time and expertise. Thank you, Vicki, for all your support in the chat and Q&A today and being so ready with all those answers and resources. And this is the type of support that you get on that complimentary HR hotline. So make sure you take note of that number. That is in the PDF slide deck that I dropped into the chat momentarily. I'll be emailing that out to some people that weren't able to download it as well. But that will be in that PDF. So make sure that you take note of that. And we'd love to work with you 8 a.m. to 5 p.m. Monday through Friday. We'll see you all on the next webinar and talk to you soon on that hotline. Have a good week, everyone. Thank you. Cheers.